Agency law forms the foundation of the relationship between real estate professionals and their clients in Arizona. Every transaction involves at least one form of agency, and understanding these relationships is essential for ensuring that licensees act with integrity, loyalty, and compliance with state law. In Arizona, the laws governing agency relationships are established under ARS Title 32, Chapter 20, and are further clarified through the Arizona Administrative Code R 4-28-1101, which outlines a licensee's duties of honesty, disclosure, and fiduciary care. Agency is more than a legal concept. It is a representation of trust, where the client, known as the principal, authorizes the licensee, known as the agent, to act on their behalf in a real estate transaction. There are several types of agency relationships recognized under Arizona law, including buyer agency, seller agency, dual agency, and limited representation. Each carries distinct duties, disclosure requirements, and potential risks that must be understood to prevent conflicts of interest or violations of ADRE regulations. The key to managing these relationships effectively lies in the principles of transparency, written disclosure, and informed consent, as mandated by ARS Section 32-2153 and R4-28-1101A. A seller's agent, often referred to as a listing agent, represents the property owner in marketing, negotiating, and closing the sale of real property. Sometimes this gets a little confusing. The selling agent is the buyer's agent. The owner's agent is the listing agent. Under AACR 4-28-1101, the agent owes the seller fiduciary duties, including loyalty, confidentiality, full disclosure, reasonable care, and obedience to lawful instructions. For example, if a seller hires an agent to list their home at $550,000, the agent must market the property in the seller's best interest, maintain confidentiality regarding the seller's motivations, and disclose all material facts that could affect the transaction. If the agent learns of a potential defect in the property, such as a roof leak, they must disclose it to potential buyers. As required by R4-28-1101B, failure to disclose known material defects may result in disciplinary action by ADRE for misrepresentation. Conversely, a buyer's agent represents the purchaser in finding, evaluating, and negotiating for a property. This agency type was recognized more prominently in Arizona after the adoption of the Buyer-Broker Employment Agreement, which defines the relationship between the buyer and the agent in writing. The buyer's agent owes fiduciary duties similar to those of a seller's agent: loyalty, disclosure, diligence, confidentiality, and obedience. For instance, if a buyer's agent discovers that a seller has already received multiple offers, they must inform their client to assist them in making an informed decision. However, the agent must also avoid disclosing confidential information from the seller or any other party not authorized to receive it. A more complex arrangement is dual agency, which occurs when one licensee represents both the buyer and the seller in the same transaction. In Arizona, dual agency is permitted only with prior informed written consent from both parties, as mandated under ARS Section 322153 and Rule R42811F. This consent is obtained using the Consent to Limited Representation form, which outlines the limitations on the agent's duties in such situations. In a dual agency, the agent cannot advocate for one party over the other or disclose confidential information that would disadvantage either client. For example, an agent representing both sides cannot reveal that the seller would accept a lower price or that the buyer would be willing to pay more. The agent's duty is to remain neutral and facilitate the transaction fairly for both parties. Failure to obtain proper consent or to act impartially in dual agency can lead to license suspension or revocation. Arizona law also recognizes limited representation, which is a form of agency created when a broker or salesperson represents two clients in the same transaction. But with restricted fiduciary obligations, limited representation allows the licensee to assist both parties without creating an adversarial relationship. But it limits the agent's ability to advocate for either party's position fully. The concept of limited representation balances the need for transparency with the prohibition against favoring one party over another. To illustrate these principles, consider a scenario where a listing agent receives an offer directly from a buyer who is not represented by another agent. If the listing agent wishes to represent the buyer as well, they must first disclose their existing relationship with the seller and obtain written consent from both parties to act in a limited capacity. If either party declines, the agent must refer the unrepresented buyer to another licensee or proceed with only one representation. This protects the agent from a potential conflict of interest and ensures that both parties understand their rights and limitations. The duties of an agent, regardless of agency type, are rooted in fiduciary responsibility. These duties include loyalty, ensuring that the client's interests come before the agent's; obedience, following lawful instructions; disclosure, revealing all material facts; confidentiality, protecting private client information; reasonable care, acting with competence and diligence; and accounting, properly handling all funds and documents. The ADRE emphasizes these duties as non-negotiable ethical and legal obligations for all licensees under R4-28-1101. Agency violations often stem from misunderstanding or mishandling these relationships. For example, if a licensee fails to disclose dual representation or provides advice favoring one client over another, it may constitute a conflict of interest and grounds for disciplinary action under ARS Section 322153. Court cases, such as Barnes v. Lopez, 1985, highlight that an agent who fails to disclose all known material facts or breaches fiduciary duties can be held liable for damages and subject to license penalties. Understanding the types of agency is not just about compliance. It is about protecting clients' rights and fostering ethical practice. Each relationship demands clarity, disclosure, and documentation. Agents should use written employment agreements, explain agency options to clients at the beginning of the relationship, and maintain consistent communication throughout the transaction review summary. Arizona recognizes several types of agency relationships, including seller's agency, buyer's agency, dual agency, and limited representation. Each type carries specific fiduciary duties established under ARS Section 322153 and R42-81101, including loyalty, confidentiality, and disclosure. Dual agency requires informed written consent from both parties, and limited representation allows for neutral facilitation rather than advocacy. Violations of agency law, such as failing to disclose representation or breaching confidentiality, can result in license suspension, revocation, or civil liability. Understanding and honoring agency obligations ensure compliance, client protection, and professional credibility. Discussion: what is the key requirement for practicing dual agency in Arizona? Answer: dual agency requires informed written consent from both the buyer and seller as outlined under R4-28-1101F. Why must agency relationships always be disclosed in writing? Answer: written disclosure ensures transparency, clarifies the agent's role, and protects all parties from misunderstandings or conflicts of interest under ARS Section 32-2153A2. How does limited representation differ from traditional agency? Answer: limited representation allows an agent to represent both parties in the same transaction, but with restricted fiduciary duties, preventing full advocacy for either party while maintaining fairness and neutrality. Closing remarks. Agency relationships form the ethical backbone of real estate practice in Arizona. Whether representing a buyer, seller, or both, a licensee's duty is to act with honesty, care, and full disclosure. The agency laws ensure that every transaction is guided by fairness, transparency, and accountability. By mastering the principles of agency, licensees protect their clients, their reputation, and the integrity of the real estate profession as a whole.